So we're visiting chapter 19 of the Mysteries of the Silent Brotherhood of the East. We're dealing with Yahshua takes the sixth degree and passed the sixth adept chamber of the Eastern sages. In all the land, there was no place more grandly furnished than the beauty parlors of the Temple of the Sun. Temple of the Sun. Few students have entered these rooms. The priests guarded them with awe and called them halls of mystery. When Yahshua had attained the victory over fear, he gained the right to enter here. The guide led on the way, and after passing many richly furnished rooms, they reached the Hall of Harmony, and there was Yahshua left alone. And among the instruments of music was a harpsichord, and Yahshua sat in thoughtful mood inspecting it, when quietly a maiden of entrancing beauty came into the hall. She did not seem to notice Yahshua as he sat and mused, so busy with his thoughts. She found her place beside the harpsichord. She touched the chords most gently, and she sang the songs of Israel. And Yahshua, entranced, such beauty he had never seen, such music he had never heard. The maiden sang her songs. She didn't seem to know that anyone was near. She went her way. And Yahshua, talking with himself, set out, What is the meaning? What is the meaning of this incident? I did not know that such entrancing beauty and such queen-like lovingness were ever found among the sons of men. I did not know that voice of angel ever graced a human form, or that seraphic music ever came from human lips. For days he sat entranced, Yahshua in awe. The current of his thoughts was changed. The current of his thoughts was changed. Current. Once again, dealing with electricity, ebb and flow, direction of movement. He thought of nothing but the singer and her songs. He longed to see her again, and after days she came. She spoke and laid her hand upon his head. Her touch thrilled all his soul, and for a time forgot the work that he was sent to do. Few were the words the maiden said. She went her way. But then the heart of Yahshua had been touched. A love flame had been kindled in his soul, and he was brought to face the sorriest trial of life. He could not sleep. He could not eat. The thoughts of the maiden came. They would not go. His carnal nature called aloud for her companionship. And then he said, Lo, I have conquered every foe that I have met. And shall I now be conquered by carnal love? My Father sent me here to show the power of love divine, that love that reaches every living thing. Shall this pure universal love be all absorbed by carnal love? Shall I forget all creatures else and lose my life in this fair maiden? Though she is the highest type of beauty, purity, and love, into its very depths, his soul was stirred, and long he wrestled with the angel idol of his heart. But when the day was almost lost, his higher ego rose in might. He found himself again, and then he said, Although my heart shall break, I will not fall in this my hardest task. I will be victor over carnal love. And when again the maiden came and offered him her hand and heart, he said, Fair one, your very presence thrills me with delight. Your voice is benediction to my soul. My human self would fly with you and be contented in your love. But all the world is craving for a love that I have come to manifest. I must then bid you go, but we will meet again. Our ways on earth will not be cast apart. I see you in the hurrying throngs of earth as minister of love. I hear your voice in song that wins the hearts of men to better things. And then, in sorry and in tears, the maiden went away, and Yahshua was alone again. Instantly, the great bells of the temple rang. The grotto blazed with light. The Hierophant himself appeared and said, All hail, triumph Logos. Hail the conqueror of carnal love stands on the height. And then he placed in Yahshua's hand a scroll on which was written, Love Divine. Together, they passed from the grotto to the beautiful temple. And in the banquet hall, a feast was served. And Yahshua was honored. And Yahshua was the honored guest. So as we see here, we have another chapter with a test that Yahshua goes through, passes the test. I want to open the floor on thoughts about this particular test.
So I wrote down some key words that stood out to me about this whole chapter. So the first word I wrote is siren, then it's test, temptation, attachment, distraction, stay true to self, and stay focused on your path. So along this journey, you're going to be put in situations that are meant to basically knock you off your balance. So if you stay focused on the other things that's distracting you and not staying focused on yourself, you're going to get distracted from your path and you're not going to pass the test.
Wow.
Islam. Mm-hmm.
Islam.
Mm-hmm.
Any other thoughts?
Islam. So this chapter really is in alignment with today, and just going through the chapter, hearing how, these are carnal desires, I think as we come into our higher self and knowing, you get to a point where it's very easy to see that line in between what is the best for your higher self or what are those other distractions. As clairvoyant creations was saying, you're going to be met with these different things along your path. And I believe like when you get to a certain point, you really can't lie to yourself. You know that you're going to just have to keep pushing forward, whether that be a journey walking alone for that moment until you're met with your right people, because that's for the best of humanity, of the world. You can't just get so lost in one certain thing, you forget about all your other duties. So it really hit today.
Wow.
Islam.
Yeah.
Islam.
I like the fact that you said don't lie to yourself. And a part of not lying to yourself comes from doing the shadow work. So you're able to process those emotions and those feelings But a lot of people run from shadow work because they scared to sit with those feelings and those emotions because it's not fun. Like, but it has to be done in order to grow.
Mm-hmm.
Say, know thyself, and to thyself be true.
Mm-hmm.
Let oneself be true.
It's
I feel like that's the only way to get to your heart of Allah is to be true. He's true.
Mm-hmm.
So
Mm-hmm.
Can you scroll to the next page so I can see the bottom of the I didn't see past number 15. Okay. Thank you.
Yep, it's live.
It's yeah, this is like a real heavy, like special chapter because it's like first of all, as a man, most men think they can go up against any known danger, right? Any trial and adversary, especially if it's coming from another man. But this one hit him in a place he didn't know he had to guard. And it took him to a place where he almost sounded like a poet pimp in the beginning. Like he was like starstruck big time.
Mm-hmm. Mm-hmm.
And then he caught himself, but he meant everything he said, but he was like, I still can't fall for that. Like
Mm-hmm.
in the day, anything that's not of this vibration that we talking about is a distraction, like a distraction or something to try to test me again.
Mm-hmm.
So he had to go deep in this. So like he having dreams, or seeing her, hearing, like this serious. This is the first test he actually like. It's like he got hit in the face. Like he got hit for the first time in the ring.
Mm-hmm.
Usually he's one punch man. He gonna knock you out. But this time he's like, I didn't know a fight could come in this type of package, basically.
Mm-hmm. Mm-hmm.
But once you overcome something like that, it makes you into the ultimate warrior, I would think.
Mm-hmm.
Islam.
That's how the spiritual warfare works when it comes to certain stuff. They go send you something in the shiny package that you like, and if your discernment is not up, you go fall for it every time. Like, and that's why it's a whole lot of people out here in relationships they don't really want to be in because they scared to be true to themselves and admit like this shit is not for me. So yeah, they get stuck.
Yeah.
Mm-hmm. Islam.
Wow. Any other thoughts for retransition? All right, so let's transition to where we left off in the law etiquette. Hearing. In law, a hearing is a proceeding before a court or other decision-making body or officer, such as a government agency. A hearing is generally distinguished from a trial in that it is usually shorter and often less formal. Law definition of hearing: proceeding of relative formality, general public, with definite issue of fact or of law to be tried, in which parties proceeded against have right to be heard, and is much the same as a trial and may terminate final order. In Race Securities and Exchange Commission, DCNY, etc., that's the res judicata, synonymous with trial and includes reception of evidence and arguments thereon, Graham versus Michaels. It is frequently used in a broader and more popular significance to describe whatever takes place before magistrates clothed with judicial functions and sitting without jury at any stage of the proceedings subsequent to its inception, and may include proceedings before an auditor. Mernon versus Bowman Dairy Company. In equity practice, the trial of the case, an alluding introduction of evidence, argument of counsel, and decree of the court. Wolf versus Wolf. Law definition of hearsay. Okay. Hearsay. Evidence not proceeding from the personal knowledge of the witness, but from the mere repetition of what he has heard others say. That which does not derive its value solely from the credit of the witness, but rests mainly on the veracity and competency of other persons. The very nature of the evidence shows its weakness, and it is admitted only in specified cases from necessity. State versus Ali, and also Young versus Stewart. We cross-reference that info. It is secondhand evidence, right? Hearsay is secondhand evidence as distinguished from the original evidence. It is the repetition at secondhand of what would be original evidence if given by the person who originally made the statement. Literally, it is what the witness says he heard another person say. Stock versus Williams, to cross-reference that issue of hearsay that was brought up in that case. Evidence, oral or written, is hearsay when it is probative force depends on, in whole or in part, on the competency and credibility of a person other than the witness. State versus Klutz, to support that. Hearsay is a statement made by a person not called as a witness, received in evidence on trial. People versus Kraft. The term is sometimes used synonymously with report. Law definition, and with rumor. So hearsay and rumor are synonymous. Interlocutory. Law definition of interlocutory. Provisional, temporary, not final. Something intervening between the commencement or start and the end of a suit, which decides some point or matter, but it is not a final decision of the whole controversy. Mora versus Sun, Mute Incorporated Company. As to interlocutory costs, decree, judgment, order, and sentence. Right, you can independently just look up those terms in law. Law definition of jurist. Jurist. One who is versed or skilled in law. Jurist. One who is versed or skilled in law. Answering to the Latin jurisprudence, or jurisprudence, right? One who is skilled in the civil law or law of nations. Y'all should look that term up independently. Law of nations. Jurisprudence. law of the land, protocols. The term is now usually applied to those who have distinguished themselves by their writings on legal subjects. Law definition of indictment. Remember, Fifth Amendment speaks of this language. Indictment. Fifth Bill of Rights. One must be indicted by a grand jury. And accusation in writing found and presented by a grand jury, legally convoked and sworn to the court in which it is impaneled, charging that a person therein named has done some act or been guilty of some omission, which by law is a public offense, punishable on indictment. Kinney versus State to support that. A presentment differs from an indictment, right? A presentment and indictment are two different things. In that it is an accusation made by a grand jury of their own motion, either upon their own observation and knowledge or upon evidence before them, while an indictment is preferred at the suit of the government and is usually framed in the first instance by the prosecuting officer of the government and by him laid before the grand jury to be found or ignored. And information resembles in its form and substance an indictment, but is filed at the mere discretion of the proper law officer of the government without the intervention or approval of a grand jury, and an affidavit is a charge made and preferred by an individual. Law definition of presentment. In criminal practice, the written notice taken by a grand jury of any offense from their own knowledge or observation. So that's why we went over hearsay, because the foundation is being laid, in this case with presentment, written notice taken by a grand jury of any offense from their own knowledge or observation, which is not hearsay, right? Without any bill of indictment laid before them at the suit of the government. The writing which contains the accusation so presented by a grand jury. In an extended sense, the term includes not only presentments properly so called, but also inquisitions of the office and indictments found by a grand jury. An informal statement in writing by the grand jury representing the court that a public offense has been committed, which is triable in the county, and that there is reasonable ground for believing that a particular individual named or described therein has committed it. An accusation of a crime made by a grand jury from their own knowledge or from evidence furnishing them by witnesses or by one or more of their members. Transitioning to 3 preliminaries: presentment of evidence, due process. The parties are summoned to a preliminary hearing. they are properly identified and evidence is provided by both the plaintiff and the accused party. The plaintiff, injured party, properly identifies him or herself and names him or herself on the record. The accused party, defendant or respondent, does the same and names himself or herself for the record. We're going down due process, order of operation. The plaintiff then properly identifies the accused as the defendant on the record. A plea is entered. Once a plea is entered, the accused becomes a defendant, and the issue proceeds to trial or pretrial at the court's discretion. And once again, this is due process. Law definition of plaintiff. A person who brings an action. The party who complains or sues in a personal action and is so named on the record. Plaintiff in error, the party who sues out of writ of error to review a judgment or other proceeding of law. Law definition of accused. Accused is the generic name for the defendant in a criminal case and is more appropriate than either prisoner or defendant. The person against whom an accusation is made, one who is charged with a crime or misdemeanor. The term cannot be said to apply to a defendant in a civil action, Castle versus Houston, and see Mosby versus Inks. Law definition of defendant. A person defending or denying the party against whom relief or recovery is sought in an action or suit. And it's like 6 case laws to support that. Law definition of plea. Common law practice, a pleading, anyone in the series of pleadings, more particularly the first pleading on the part of the defendant. In the strictest sense, the answer which the defendant in an action at law makes to the plaintiff's declaration, and in which he sets up matter of fact as defense, thus distinguished from a demur, which interposes objections on the grounds of law. Equity, a special answer showing, and in law, equity is, when you look up equity, is dealing with fairness, just being fair based on the law. Is not like in real estate or I guess that's real estate terms or whatever. They'll say equity as in the value of your house or something like that. That's not what equity means in law. It just simply means being fair based on the laws that are already in place. A special answer showing or relying upon or more things as a cause why the suit should be either dismissed or delayed or barred. A short statement in response to a bill of inequity of facts which, if inserted in the bill, would render it demurrable. So demur If anybody's not familiar with that, I will look up demur, DEMUR, or demurrer. And you're basically saying it was an error in law somewhere. While an answer is a complete statement of the defendant's case and contains answers to any interrogatories the plaintiff may have administered. The following relate to the secure rights of the people as embodied within the American Constitution. Whenever anyone is accused of a crime or charged with an offense, the following rules are to be known, preserved, followed, and acknowledged as they are firmly in accord with the supreme law of the land. Jurisprudence. So, first, accused must be properly identified. The accused must be properly identified in such a fashion there is no room for mistaken identity. Right? Who are you? The individual must be singled out from all others. Otherwise, anyone could be subject to arrest and trial without benefit of wrong party defense. Almost always, the means of identification is a person's proper name. But any means of identification is equally valid if said means differentiates the accused without doubt. There is no constitutionality valid requirement. You must identify yourself. See the Fourth Amendment. Also see Brown versus Texas and Collender versus Lawson. Statute of offense must be clearly identified. The statute of offense must be identified by its proper or common name. A number is insufficient. So what was the crime? A violation of Penal Code, whoop-de-whoop-whoop-whoop. That is not identifying what a crime is. Today, a citizen may stand in jeopardy of criminal sanctions for alleged violations of statutes, regulations, or even low-level bureaucratic orders. Example, Colorado National Monument Superintendent's orders regarding an unleashed dog or a dog defecating on a trail. If a number were to be deemed sufficient, government would bring new and different charges at any time by alleging clerical error. For any act to be triable as an offense, it must be declared to be a crime. Charges must negate an exception, forming part of the statutory definition of an offense by affirmative non-applicability. In other words, any charge must affirmatively negate any exception found in law. So, identify the crime. Identify the injured party. Identify the party that did the injury. Offense or nature of charge must be intelligently described. The acts of alleged offense must be described in any non-prejudicial language. The acts of alleged offense must be described in non-prejudicial language and detail so as to enable a person of average intelligence to understand the nature of the charge. Must be laid out simple, right? To enable preparation of a defense. The actual act or acts constituting the offense complained of. The charge must not be described by parroting the statute, right? So just parroting, you violated penal code, whoa. That's not identifying a crime. Where's the injured party? Where's the due process? Where's the indictment papers? Where's the human being with a sworn affidavit saying I did X, Y, Z? Where are these things? Not because I want these things to happen, it's because that's the measure and stick in law called due process, which is a collective of the Fourth and Fifth Amendment, says these things must happen. Right? The naming of the acts of the offense describes a specific offense, whereas the verbiage of a statute describes only a general class of offense. Facts must be stated. Conclusions cannot be considered in the determination of probable cause. Accuser must be positively identified. The accuser must be named. He, she, accuser may be an officer or a third party, but some positively identifiable person or human being must accuse. Some certain person must take responsibility for the making of the accusation, not an agency or institution. So back to injured party. The city of whatever cannot be the injured party because corporations can't talk. A board member or an officer of an organization or corporation or institution can say you injured them, but then that person of that organization would be like, I, John, David, whatever, and making the claim. Walmart can't talk, right? This is the only valid means by which a citizen may begin to face his accuser. In that lingo, face your accuser. Sixth Amendment, Sixth Bill of Rights. That's another guaranteed right that you have, is to face your accuser. Oh, somebody accused me of something? Where are they at? Where's the affidavit? Also, the injured party, corpus delicti, must make the accusation. Hearsay evidence may not be provided, right? Hearsay evidence, that doesn't fly in law. That flies in loose conversations at the barbershop or on the side of the corner. But when you're dealing in law, hearsay don't matter. The accusation must be made under penalty of perjury. And that's in harmony with the 10 maxims of law. I brought that up on numerous occasions, but under penalty of perjury, if a injured party is entering a sworn affidavit, an element of an affidavit, just period, you got to conclude it with, like I say, I swear that this is the truth, the whole truth, under whatever, laws that, whatever your creed. In our case, we're going to, and be in harmonies with our holy books. Indigenous rights, Constitution, treaty, but you always conclude an affidavit with, this is the truth, the whole truth, right? So so the accusation must be made under penalty of perjury. The accusation must be made under penalty of perjury. If perjury cannot reach the accuser, there is no accusation. Otherwise, anyone can accuse another falsely without risk. Right? That's the whole point. Accused must be accorded due process, right? Repetition on due process. The accused must be afforded due process. So now we know what due process is. We've probably heard that term all our life, but now you know what due process is. So to comply with the 5 elements above that are for the accusation to be valid, the accused must be afforded due process. The accuser must have complied with law, procedure, and form in bringing the charge. This includes court-determined probable cause, summons and notice procedure. If lawful process has been abrogated in placing a citizen in jeopardy, then any means may be utilized to deprive a man of his freedom, and all dissent may be stifled by the utilization of defective process. So once again, people got to know law at large. The essential elements of due process are notice and an opportunity to defend. Simon versus Kraft. One is not entitled to protection unless he has reasonable cause to apprehend danger from a direct answer. And the mere assertion of a privilege does not immunize him. The court must determine whether his refusal is justified and may require that he is mistaken in his refusal. Hoffman versus United States. The court must be of competent jurisdiction, properly delegated authority, right? Now we back Article 3, Section 2, space. The court must be one of competent jurisdiction to have valid process. And that word competent is also codified in manuals, such as the Department of State Consular Notification and Access Manual. It'll talk about officers. The manual is based on officers' competence of the manual or an international law dealing with people in different jurisdictions, i.e. people with nationalities. To have valid process, the tribunal must be a creature of its jurisdiction, in accord with the law of its creation, i.e. Article 3 judge, right? Or Article 3 court. And why is it Article 3? Is based on Article 3 of the Constitution, Section 1 and 2. And it spells out you're dealing with disputes of 2 different citizens of 2 different nations. And it's really supposed to be Supreme Court to even handle that. Or whenever a national goes in any building that calls themselves a court, the more or the national turns that building into an international venue just based on the mode of the court has to change. Like, okay, this is who I am. So now, based on that, are you competent to deal with matters of international law, constitution, or treaty? But like I say, people, first of all, I got to be competent and have a sound mind and know what they're doing at large. And then things will change at a greater clip. So back to competency of the people, organization of the people, intellectual faculty of the people, knowing who they are, It's being in honor with your ancestors, which means you know law. That, especially Moors, Bays and L's, Bay, that's the enforcer of the law. Anybody with a Bay. So remember, we don't want to be deemed as being a fraud. If you're saying you're somebody or a nationality of people that are at large known for being, you know, precise in law and amongst other things, and then you're not, you come in like you're not that, or your actions are showing that you're not that, then that's a crime in itself. Lacking any of the 7 elements or portions thereof, unless waived intentionally or unintentionally, all designed to ensure against further prosecution or double jeopardy. It is the defendant's duty to inform the court of facts alleged for determination of sufficiency to support conviction, should one be attained. Otherwise, there is no lawful notice, and charge must be dismissed for failure to state an offense. Without lawful notice, there is no personal jurisdiction, and all proceedings prior to filing a proper trial document in compliance with the 7 elements are void. A lawful act is always legal, but many legal acts by government are often unlawful. Most bureaucrats lack elementary knowledge and incentive to comply with the mandates of constitutional due process. They will make mistakes. Numbers beyond count have been convicted without benefit of governmental adherence to these 7 elements. Today, claims are being filed and prosecuted by quote unquote accepted practice rather than due process of law, for people's lack of knowledge at large, right? Of law in the first place. Estoppel. Estoppel is a collective name given to a group of legal doctrines in common law legal systems whereby a person is prevented from asserting certain matters before the court to prevent injustice. The person is said to be estopped. Estoppel may operate by law or by way of preventing someone from asserting a particular fact in court, or exercising a certain right, or from bringing a particular claim. Law definition of estop: to stop, bar, or impede, to prevent, to preclude. Case law to support Altegard versus Lemenke. I'll stop right there. We'll pick it up on Friday. We'll continue this section. I want to open the floor for any thoughts, questions. And I know a couple people came in here as I was reading. Islam to Brother Pierre. Islam to I think that was it. Somebody else I seen. But yeah, I'll open the floor for any thoughts or any questions.
Islam.
Islam.
So when I forgot which part, it may have been a couple pages ago, but I kind of cross-referenced something. It made me think, and I pulled out the Moorish Tactical, and I went to the page 20 where it's talking about Article 4, Section 1 of the Constitution, the full faith and credit. And then I was looking back over the HR 1203 stating that Moorish Americans are Aboriginal and Indigenous. Basically, it kind of everything click, like that's the foundation of your status. So then that makes it different when you're approaching law. Once you know and you're able to, like you said, build on that as a whole. So I'm still studying, like things are starting to turn, gears are turning and moving as you're saying these things, and we're reading this all together. And just that, like the self-identification, how there's like a lot of threats with the policy enforcers. Oh, if you don't identify, I'm gonna take you to jail, and like all of these threats. And then going back to that inner American Declaration of Rights of Indigenous Peoples, stating basically they're not going to pressure us to show them what they think identification is kind of like what I'm getting from that. But like I said, I'm still studying. The gears are starting to turn a lot more.
Yeah, that's good. And yeah, all the case law that you see, just think Article 4, Section 1, introduce, you know what I mean? Like you say, HR, any House resolutions, and it sets the tone, you know, for your status, you know. And I'm glad that stood out. Because once again, you know, the organization of your thoughts, organization of people, it is powerful when you just know what you're talking about. And you're able to, you know, case in point, like how you did the presentation. If you want open court, it's the same thing. It's a presentation that you know what you're talking about. You know what I'm saying? And you want to have it on the record that you knew what you was talking about. So if you get an unfavorable reply, you start pushing things up, you know, the ladder in the appellate process. You want to just be in a good position. And like I say, sometimes you'll get a favorable reply right there in open court. You know what I'm saying? Or sometimes they'll just keep doing continuances till the wheels fall off. Maybe a whole year of continuances, and then it's just never a date to come back or nothing. Like, you know what I'm saying? So yeah, that's knowing your tools. You know what I mean? And me personally, that's one of the easiest ones. Like, you got to remember, these things are codified in these municipalities, city halls that were Aboriginal and Indigenous. So it's not like they're trying to hide it. They just, they're giving us breadcrumbs and like, man, look, y'all need to start uniting out here. You know what I'm saying? There's tools out here we can use. But yeah. Any other thoughts, Empress, or anybody else on that matter? On the information, court etiquette, law definitions, anything at all, constitutional treaty. I think we got Ali next. Presentation. And once again, anybody that wants to do a presentation on, it could just even be what they know now, or they could, you know, history, law, it could be anything. The whole goal is to get it out in an organized fashion. These are good exercises to show not only did you digest the information, but you're able to explain it in an organized way that maybe, you know, enlighten somebody. And when you're able to do that, that determines your status. That in itself is what, you know, separates people from different statuses. is their competence and their character and how they moving, you know. So um, yeah, Islam Pierre, Islam. So once again, did anybody have any, any other thoughts, just in general, or anything?
I had a question.
All right, go ahead.
Where can I find that music though? That music was fire from that little meetup. You know what I'm saying? Like, I've been trying to get that on my playlist. I know your Spotify count been going up, and these exclusive tracks ain't dropped to these streets yet. You know what I mean? The streets is hungry. I'm trying to get this on my playlist. What's goody with that though?
Man, it's almost, you know, I'll say in about a month, maybe less. It'll be out. I'm working on a couple of things like CD, artwork for the album cover, and I just got a verse from Word L. Actually, just AM. So I gotta do my part. It's like gonna be like one of my last songs for the album, and then that much closer to releasing it.
All right, so the singles coming out shortly. It's a whole album drop. All right, cool.
Well, I'm glad you said that because that was my next thing too. What might make it a little longer. I want to figure out what song that I want to make the anchor and shoot a video for it and stuff like that.
As well.
But